Johnson v. NCAA. Wait a second. The NCAA is in court. There is no way that this is going to turn out well. Brian Murphy, WRAL Sports Investigative Reporter, joins us now on the Adam Gold Show. So I saw Michael McCann from Sportico started a tweet thread like this. It was a disastrous day in court for the NCAA, and all I could think of was, when isn't it a disastrous day in court for the NCAA?
Well, I listened to the proceedings because you can't watch; you can only listen. And yes, just from I'm not a lawyer, but from the sound, from the questions that were being asked and the way the judges were asking questions of the attorneys on both sides, it certainly seemed like the NCAA was in a world of trouble. And this case is about whether or not student athletes are employees of the university and should make minimum wage. At least minimum wage. This is at the Third Circuit Court of Appeals, and this is only on the NCAA wants the case dismissed outright. And so then the plaintiffs were obviously saying, no, the case should move on. And the judges seem to indicate that the case should move on, that there's no way to and so this will end up going back to the district court. So it's a long process, but another seemingly disappointing day for the NCAA.
I'm at a loss for why the NCAA is even trying to. I mean, I guess I understand why you're trying to get the case dismissed, because and it's not going to be dismissed, so there will be discovery here, and that's a problem for the NCAA. But this exchange is one of the. I mean, there's a lot of really embarrassing exchanges for the NCAA here, but when the lawyer representing the NCAA says this is not about Division I athletes, and the judge responds, "This is about Division I athletes." Like, what could it possibly be? What else could it be about?
Well, the NCAA wants, they want to look at everybody from Division I all the way to Division III, and say, well, you can't. There's no one size fits all for all these people, so you have to just dismiss the case. And if some of them aren't employees, then none of them are employees. And one of the judges said, well, we may see a situation where the quarterback in an SEC school is treated differently than someone who runs cross country at Alabama.
Right.
In another part, the judge said, I'm finding it really hard to find any way that they're not employees, which obviously this case is only about deciding whether or not to dismiss. But the larger tenet is to find out whether or not they are employees. And one of the judges was like, help me come up with a way to decide that they're not employees. And nobody really had a good explanation for that.
No, because the NCAA doesn't. And this exchange kind of, I think, plays into that. The NCAA attorney argued that they're not professional athletes because they're, from the school perspective, even today, there is not the expectation that they will be compensated beyond the scholarship by the schools. And the judge said, well, isn't that because you've deemed it so? So, and I keep bringing up Brett Kavanaugh's concurring opinion back in the case, what is now, about a year and a half ago, 2 years ago, in which he said, I don't know how they've been getting away with this for decades already at this point. How are they not being paid?
Yeah, this came up in the case too. The judges were like, well, if they've always been employees, why hasn't it been so? And I think what's really changed is the money, right? There was a time where coaches were paid like college professors.
Yeah.
And so you could make a case that, look, nobody's getting rich off of this. They're getting an opportunity to play. Obviously, over the last 25 years, that has changed dramatically, and especially in the last 10 to 15 years, it's changed exponentially. And those arguments, I don't think, are holding as much water as they once did. This is why the NCAA hired a president who's basically a lobbyist. They're going to Congress to fix this problem because I don't think they can win in the courts anymore.
Yeah, but I don't think they can win in Congress either, because I don't think there's the motivation in Congress to, I don't even say fix, because I don't know that anything is going to be fixed, basically to protect what the NCAA wants to do, which is go back to the old system. The people involved in college athletics, in my opinion, prefer the collegiate model. And you mentioned, I think, the money, and because it is literally the money quote, is that it's about money and the increase in money. I would be all in favor of the collegiate model being the case if the sport isn't if football wasn't worth billions of dollars at this point, because 25 years ago it wasn't billions of dollars. So now it is, and we still have this thirst for more money. Like, where's that money going?
Right. I mean, that's we've seen it, the proliferation of facilities and coaching salaries and everything else to not give it to the players. And now we're seeing, with NIL, some of that money is getting to the players. But I think that these challenges, and you mentioned the Kavanaugh concurrence, are going to keep happening. And all it takes is for the NCAA to lose one of these cases, right? The cases can keep coming. They've got to bat 1,000. The plaintiffs really only got to win one for the whole system to come crumbling down. And I'm just not sure the NCAA is prepared for what comes next. I mean, I think we've seen with NIL, they weren't prepared for what was going to happen when they changed those rules. I'm not sure they have a contingency plan for what happens if and when the federal government decides these are actually employees. One of the big parts that the plaintiffs are making is it has less to do with scholarship and compensation and more to do with all of the other demands you're putting on these athletes that make them employees.
Yeah.
The fact that they can't gamble, which obviously is a minor one, but that they can't go to the classes they want to go because it interferes with practice.
Right.
That they can't work outside jobs. They can't do this. They can't do that. These are terms of employment. Me and you have to deal with some of that same stuff. Working at the company that we work at. When you work for an employer, they put terms of employment in place,
yep.
and you either follow that or you don't have a job. Well, for these college athletes, you either follow that or you don't no longer play on the team. And now, and the team's arguing, well, that's not an employment based contract, and the plaintiffs are arguing that's exactly what it is.
A gentleman named Romy Hamuga, I totally botched his name, and I apologize. Who is in charge of an organization that is trying to organize college athletes. He represents the interest of college athletes in an unofficial capacity, but he has said for years that the biggest issue is healthcare. And if you could get workman's comp as a college athlete, if they offered that, they might have been able to head this off a decade ago if they had really thought forward about, all right, we have so much more money coming in. We're playing longer seasons. We're going to expand the playoff. We're going to ask more of these football players. What can we do for them? But all of that's been lip service from the NCAA, and every time I hear them say, well, it's really about the student-athlete experience, I want to punch somebody.
Well, the attorney in this case said probably the easiest way is to loosen all of that extra stuff, to let players major in what they want to major in, to miss practice for a class, to loosen some of the restrictions on what they can do with their outside time. Some of that would maybe not make them employees, but obviously that's probably not going to happen, and this case is going to move forward, and there are other challenges out there, but this I think represents the biggest threat to the NCAA since the Alston case.
All right, so final thing for Brian Murphy from WRAL. He's the sports investigative reporter, because you mentioned NIL. And I know it came up during this, and for those people who don't know, name, image, and likeness, we just call NIL now, is the ability for a third party, in some cases it's corporations, to compensate players for their time and effort and exposure. I know it's happening. We have Jeremy Roach for Duke and Armando Bacot for North Carolina, each repping the same product. But it's also allowing boosters and collectives to pay the players, which used to be illegal but now is not. How does NIL kind of impact this situation, or does it?
I think, it didn't come up a lot in this case. This case was much more about whether they're employees of the university or employees of the football program. But I think what it does is show that there's a robust market. I mean, as if we didn't already know there was a robust market for the services of these players. There is a robust market. The NIL has proven that, at least at the top end of Division I football and men's basketball. And so, this can be seen as a restraint of trade when all you can offer is a scholarship or all you can offer are these additional things. It can be seen as a way to, keep labor costs down, that you're putting an artificial limit on what players are worth. And I think that's where NIL has, we've always thought there was a market. Now, clearly, the market has demonstrated there is a market for these players.
Brian Murphy, WRAL Sports Investigative Reporter at Murph's Turf on Twitter. I thank you very much for your time. We got to do this on a regular basis. What do you say?
Let's do it.
All right. Well, I'll talk to you later, man. Appreciate your time.